Good evening and best greetings to our subscribers. Today I would like to tell about the employment laws in Russia. Employment law is based on Russian labor code adopted in February in 2002 with the last amendments of 20 and 07 years and on current year. The Russian labor code establishes the rights of an employee and the employer. The employment law applies to all types of companies, national or foreign, and also to the employments regardless of their citizenship. If you want to start a business and you need the details about the employment contracts or how to establish business, you can contact us. The applicability of the employment legislation in Russia. The Russian labor code applies to both local and foreigner worker carrying out a paid activity in this country. Also, the employment law recognizes international treaties which might apply to certain conditions to the work contracts of working foreign employees. These international treaties refer to double taxation agreements, which refer to the taxes paid by the foreign employees, to international arbitration rules, and even to the recognition of foreign judgments. Also, in accordance with the international regulations of employment, the Russian labor code acknowledges the following types of workers. First of all, it is employees hired directly by the company in Russia. The second, it is independent contractors. It is widespread between freelance, for example. And the third, it is agency employees, workers hired through recruitment agencies in Russia or from abroad to Russia. Our attorneys can assist foreign investors invested in operated recruitment agency in Russia also, because we're providing this kind of activity also. The Russian employment contract is a very important document I would like to tell a few words about. The employment contract in Russia is the agreement between the employer and the employee. One of the articles in the Russian labor code quite clearly states that the agreement will be concluded in written and individually with every employee. Also, if some amendments appear regarding the work contracts, they will be made in writing as well, in full accordance with Article 72 of the Russian employment code. The employment contract will contain data like the work schedule, which in Russia is set at 8 hours per day, 4 hours per week, and with 28 vacation days per year. When it comes to overtime, Russian law is rather strict, demanding the employee to make a written request first. Russian employment contract is usually made on an indefinite period of time, temporary contracts being agreed upon in just a few cases. The test period is established at maximum 3 months, and in the case of dismissal during the trial period, a 3-day notice is required. It is also necessary to mention the motive of the dismissal. The Russian legislation is very strict about the employee's labor books, which should be kept and updated by the employer. The employment books contain important details about the labor records of the total working years, which are very important to the pension level the state will provide to the employment after retirement. International regulation in companies in Russia. One of the most important provisions of the employment law is Russia refers to the employment orders and international regulation workers must comply with. According to law, all companies in Russia are required to create their own rules employers must abide to. The current law provides the two types of rules, mandatory and optional ones. mandatory regulation refer to discipline at the workplaces, payment of wages, and protection of personal data of employees. In order to be valid, the mandatory regulations must be issued and accepted by the company directors, first of all, and they must be in Russian language, and the employees must be recognized by the employment by signature. Termination of an employment contract with Russia. Ending a labor contract with Russia is quite difficult once the trial period has concluded. The grounds and the proceeding for termination of contract are specially enumerated in the current labor code. The most common reason for the termination in Russia is a redundancy. In this case, the worker has the right to a 2 months paid notice and a servant's package from 1 to 3 months of time. Another reason for termination could be the lack of performance of an employee is stipulated in labor code. For example, the pregnant woman or the mothers with children younger than 3 years old cannot be dismissed in Russia. The federal labor inspector is in charge with the supervision of the employees, and it is authorized to investigate labor accidents, administrative issues, and also to violation of the employment's integrity. For the more information of the employment law and the current laws, you may contact our law firm in Russia, and we can help you with all these matters, also with how to arrange the working visa or to arrange permission to work. Thank you for your attention.